Caroline Downey is the General Counsel for the New York State Division of Human Rights, and she will be speaking with David Mossberg, who is Associate Counsel for the New York State Department of State. So Caroline and David, I'll turn it over to you.
Great, thank you. Hello, everyone. Good afternoon, and I appreciate being here. I'm going to talk briefly about some areas that concern home ownership to some degree, but also are involved with other sections of the human rights law. And the first of those, I have some slides too that we'll be taking a look at. And the first of those concerns the credit provisions of the human rights law. The credit provisions go hand in hand to some degree with the housing provisions, but to a large extent, they're separate from those. They involve a separate section of the human rights law, which is section 296A, and it involves all lending in connection with the sale of housing and other kinds of loans, but the sale of housing includes things like the purchase or repair of a home, all the kinds of areas that the commissioner talked about earlier are covered under the credit provisions of the human rights law. I'm going to get to a couple of exceptions to that in a minute, but basically they are covered. I'm looking for the slides here on mine. There we go. Just the one back a bit, I think. The credit provisions, as I mentioned, include all the granting or withholding of credit, all the terms, conditions, and privileges of credit, and not just with respect to housing. As I said, all other kinds of credit are covered under the human rights law, such as auto loans and other kinds of credit that you might be wanting to get. And the conditions of credit have been interpreted quite liberally too. There was a case at the Division of Human Rights called Yadlowski against Binghamton Services, where a credit disability loan insurance policy was found to come under our law as a condition of credit. And this we took up to the Court of Appeals. It was a case where a person had an auto loan who had a credit disability policy that she got as part of this auto loan, but turned out that when she put in a claim because she'd been out for a period of time pregnant, then and having a child, that was disallowed because pregnancy was not included. And that was changed as a result of the division's action. We took it up to the Court of Appeals. There'd actually been a Department of Insurance regulation that permitted that kind of discrimination that was later rescinded. So it's very broadly interpreted. And on the next slide, we see as to the as the commissioner and John had mentioned previously, and this is a very important part of our law, not only is the action of discrimination prohibited, but any kinds of applications and records and inquiries must also not be discriminatory. And this comes up in the context of credit, often with respect to things like, if you'll see in the second bullet there, child-bearing potential. So any kind of questions that go to any of the covered bases, and again, direct or indirect, sometimes it's quite subtle, but that express any kind of limitation that, and it's specifically referred to in the statute, child-bearing potential would be included in that. And there are other areas that would come under sex discrimination or some of the other kinds of areas that we would consider. And finally, the next point I wanted to mention on the credit discrimination provisions have to do with how a lender is permitted to assess credit worthiness. Obviously, when we're looking for credit, our own credit worthiness is going to be examined as part of getting either a mortgage or other kind of loan, but the law specifically provides that lenders may not consider aggregate statistics or assumptions relating to any of the protected characteristics. There are some little differences with respect to age there, as I said, it doesn't completely follow other kinds of areas of the law where there can be a demonstrable and statistically sound relationship between age. That can be considered in credit, but not the other kinds of aggregate statistics with respect to any other area. I want to move on to another important area of home ownership, and this is what the commissioner had referenced earlier, and some of what we saw a lot of in the Newsday article that many people are familiar with, and that's the actions of realtors. And I want to just take a look, and this is what I'm going to talk with the Department of State is going to address here too, how realtors can foster the kind of discrimination that we're trying to eradicate and what we can do about it. So it's unlawful for real estate professionals to discriminate at all in negotiating a sale or rental. Again, that goes to both sales and rentals, including stating that a property is available, is not available when it is in fact available to rent, and offering to or negotiating discriminatory terms, conditions, or privileges of a sale or lease. The kinds of areas that are covered are all the ones that we've been referring to so far in our presentation. Lawful source of income is specifically included here, and this is something that realtors have to come to terms with, because they will often use a client's, well, the client doesn't accept Section 8 or something like that. And as you see there in the second bullet, that is not permissible. Realtors are directly liable for discriminatory actions, whether or not they were requested by a client. And of course, that wouldn't be limited to source of income, but any of the other bases covered under our law. The questions on the next slide. Oh, I did want to touch, if you just go back a sec. It's unlawful, again, any kind of application, advertisement, asking any questions that any way expressed directly or indirectly, any limitation or discrimination based on a covered classification. And over the many years the law has been in effect, these kinds of questions have become somewhat subtler, but they haven't gone away. In the bad old days, there were actual checklists or little notations as to what someone's race, religion, national origin was. If we see that, it's certainly much more subtly done than it used to, but there are still many questions, and sometimes cloaked with a seeming concern for welfare. For example, in the area of familial status, a realtor might say, well, you know, I don't care if you have children, but the landlord is concerned because there's a balcony here and he worries about your children. That's not the landlord's business, and those kinds of questions, including the fact of children in the whether someone has children or not, or whether someone intends to have children, is something that can't be considered. The steering piece, which was mentioned by the commissioner, is a terrible scourge on the real estate industry. I don't think we can say anything other than that after the expose in Newsday. It is not something new. An early case going back to the early 90s of the State Division of Human Rights found racial steering, and that in that case, which was affirmed by the appellate division, that was the first time the appellate division had found punitive damages available in a housing case, confirming a division order to that effect. So the steering is described here, guiding or making recommendations to prospective buyers or renters towards or away from particular neighborhoods, locations, or school districts based on race, national origin, religion, or any of the protected bases, and it is a violation of the human rights law. In that regard, we have worked closely with the Department of State on trying to address this issue, but I wanted to, before getting to Dave's presentation, just go over a little bit more what the division can offer when a case is brought against a realtor at the Division of Human Rights. And the commissioner went over what our procedures are, and with respect to housing, and the liability of realtors, it runs the full gamut of those. It's a separate section under the law. Real estate professionals, including brokers, salespersons, and their employees and agents, can be liable under the human rights law. The human rights law covers separately a basis of liability in aiding and abetting other people in committing discrimination that it's unlawful under the human rights law, but it's also very specifically spelled out as liability under the human rights law. And our damages in many ways are unlimited, at least with respect to emotional harm. There's no limit on what the monetary damages can be on that, and many thousands to the hundreds of thousands of dollars have sometimes been awarded under the human rights law. And then we also order punitive damages that I mentioned, civil fines up to $100,000, and other training and non-monetary damages. One thing we at the Division of Human Rights cannot do, and that's something that our next speaker's agency can do, is deal with the certification and licensing of realtors. We work very closely with the Department of State now, so that so when a case comes to them or a case comes to us, we're able to jointly look at it and share information and investigations together.